All right, and if you want to test your PowerPoint. Okay. All right, we're going to go on the record. Court is calling 2021 CR 10255, State of Texas versus Jose Delbosque. Can I have parties announced for the record for the state
Allie Jackson and Zach Dunn.
and for the defense?
Gary Chirac.
And are you Mr. Delbosque?
Yes, ma'am.
All right, where we left off yesterday, both sides rested and closed. Is that correct, state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, are both parties ready to render the closing arguments?
Yes, Your Honor.
Okay, do we want to take up the
No,
charge?
we're going to take up the charge. I'm just asking.
Yes.
Are you
yes,
going to be
ma'am.
ready for closing arguments?
Yes, ma'am.
All right. Did both parties have a chance to review the charge of the court?
Yes, Your Honor.
Yes, Your Honor.
All right, off of the record, there were certain things that parties wanted to remove and certain things that parties wanted added. State, do you have any objection to the current charge of the court?
No, Your Honor.
Defense, do you have any objections?
I do, Judge, with regard to count 2 on page 5 and count 4 on page 7. I believe there's insufficient evidence to submit those charges to the jury.
All right, state.
Your Honor, there is more than enough evidence. There is both the testimony of the complainant, the testimony of the detective, as well as the state exam, which the state exam number 5. There's all it was needed is scintilla, and there is testimony as to each of the elements in both count 2 and count 4.
Yeah.
Okay.
All right. Defense, it's your argument, so I'll give you final argument or,
Basically, I'm saying, Judge, there's insufficient evidence.
all
I
right.
think the claiming witness testified it didn't happen.
Defense, your objection to the charge will be denied. Are there any other objections, defense?
Nothing further, Your Honor.
All right, with that, we'll bring the jurors in and each side, you've agreed to 20 minutes. Does anyone wish to have a time announcement?
Zach, do you need anything for coming announcement?
I will, no, thank you.
No,
but
I think we should be
appreciate
good,
it.
Judge.
Judge, give me like a 2-minute warning.
All right, will do. All right,
I'll also just in case, but
2
2
minutes.
minutes.
All right, thank you. If you'll bring the jurors in.
All right, for the jury.
All right, everyone, please be seated. Good morning. I hope everyone was able to find parking. Okay. All right, what I'm going to do is I'm going to read to you the charge of the court. You do not have to memorize it. You will be given this charge when you go back for your deliberations. Charge of the court. Members of the jury, the defendant, Jose Delbosque, stands charged and counts 1, 2, 4, and 5 of the indictment with the offense of aggravated sexual assault of a child alleged to have been committed on or about the 5th day of March, 2021 in Bexar County, Texas. To these offenses, the defendant has pleaded not guilty. The state made the decision to waive count 3. That charge will be dismissed by the court and thus it will not be submitted to the jury. 1, our law provides that a person commits the offense of sexual assault of a child if the person, regardless of whether the person knows the age of the child at the time of the offense, intentionally or knowingly causes the penetration of the anus or sexual organ of a child by any means, or causes the sexual organ of a child to contact the mouth of another person, including the actor. Our law provides that a person commits the offense of aggravated sexual assault of a child if the person commits the offense of sexual assault of a child defined above, and if with the intent of facilitating the commission of the offense of sexual assault of a child, the person provides to the victim of the offense any substance capable of impairing the victim's ability to appraise the nature of the act or to resist the act. 2, Child means a person younger than 17 years of age. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Four, count one. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the anus of Elise Morwick, a child, by Jose Delbosque's sexual organ, and with the intent of facilitating the commission of the offense, Jose Delbosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count one of the indictment, and do not consider paragraph 5, but continue on to paragraph 6. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count one of the indictment, say by your verdict not guilty of aggravated sexual assault of a child in count one, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count one as instructed in paragraph 5. 5, count one, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the anus of Elise Morwick, a child, by Jose Delbosque's sexual organ, then you will find the defendant guilty of the lesser included offense of sexual assault of a child in count one in the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count one. 6, count two. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Delbosque's sexual organ, and with the intent of facilitating the commission of the offense, Jose Delbosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count two of the indictment, and do not consider paragraph 7, but continue to paragraph 8. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count 2 of the indictment, say by your verdict not guilty of aggravated sexual assault of a child in count 2, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count 2 as instructed in paragraph 7. 7, count 2, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the 5th day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Delbosque's sexual organ, then you will find the defendant guilty of the lesser included offense of sexual assault of a child in count 2 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count 2. 8, count 4. Now, if you find from the evidence beyond a reasonable doubt that on or about the fifth day of March, 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the sexual organ of Elise Morwick, a child, to contact the mouth of Jose Delbosque, and with the intent of facilitating the commission of the offense, Jose Delbosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count 4 of the indictment, and do not consider paragraph 9, but continue on to paragraph 10. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count 4 of the indictment, say by your verdict not guilty of aggravated sexual assault of a child in count 4, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count 4 as instructed in paragraph 9. 9, count 4, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the fifth day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the sexual organ of Elise Morwick, a child, to contact the mouth of Jose Delbosque, then you will find the defendant guilty of the lesser included offense of sexual assault of a child in count 4 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count 4. 10, count 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the fifth day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Delbosque's finger, and with the intent of facilitating the commission of the offense, Jose Delbosque provided alcohol to Elise Morwick, which was a substance capable of impairing Elise Morwick's ability to appraise the nature of the above described act or to resist the above described act, then you will find the defendant guilty of the offense of aggravated sexual assault of a child as charged in count 5 of the indictment, and do not consider paragraph 11. If you do not so find, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of aggravated sexual assault of a child as charged in count 5 of the indictment, say by your verdict not guilty of aggravated sexual assault of a child in count 5, and next consider whether the defendant is guilty of the lesser included offense of sexual assault of a child in count 5 as instructed in paragraph 11. 11, count 5, lesser included offense. Now, if you find from the evidence beyond a reasonable doubt that on or about the fifth day of March 2021 in Bexar County, Texas, the defendant, Jose Delbosque, did intentionally or knowingly cause the penetration of the sexual organ of Elise Morwick, a child, by Jose Delbosque's finger, then you will find the defendant guilty of the lesser included offense of sexual assault of a child in count 5 of the indictment. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the lesser included offense of sexual assault of a child in count 5. Your verdict in each count must be unanimous. If there is evidence presented of more than one alleged instance that could constitute an offense committed by the defendant against the complainant, if any, you are instructed that your verdict on each count must be unanimous about which specific instance, if any, constituted the commission of the offense in each of the individual counts. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media, such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced into evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or persons connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict on each count, the presiding juror would certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony. But you are bound to receive the law from the court, which is hearing given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict. But jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his or her own views and change his or her opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit him and say by your verdict not guilty. Suitable forms for your verdicts are attached to the charge for your convenience, if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, each verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this case, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you retire to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Attached are suitable verdict forms. Are parties ready to proceed with closing arguments?
Yes, Your Honor.
Defense is ready.
All right, each side, you have 20 minutes. State, you may proceed.
Thank you, Your Honor. Quote, there are a lot of families that depend on me. It would be a disaster. I didn't force anything. I almost always start my closings in these cases with quotes from the victim, but the defendant's words are so deceptively despicable, I wanted to lead off with his words, right? These are the words of a 49-year-old man at the time with 2 daughters of his own, right? Who did something to someone else's daughter that I would shudder to think he would want to happen to his own children, okay? It would be a disaster. I didn't force anything. You know what's a disaster? What's truly sad and heartbreaking? You know what forced a now 20-year-old to get up on the stand to talk about a sexual assault that happened with someone 3 times her age? How about these quotes? He took my pants off. He bent me over the counter. He started having sex with me. He put his penis in my vagina and my anus. It hurt. Did he use a condom? No. Did he use lube? I don't think so. We ended up in his bedroom. We had more sex. He was touching me all over. His mouth was on my vagina. His mouth was on my breasts. That is aggravated sexual assault of a child, okay? And the aggravating element here, in the defendant's own words, when he took the stand on direct examination with his attorney, yeah, I met her at the gas station and I gave it to her, it being the 6-pack of hard seltzers, okay? Now, I want to talk to you very briefly about the jury charge, the same charge counsel has and my partner has, okay? So this is the law as not written by the state of Texas. This law is not written by the defense. It's provided by the court, but this is provided by the state of Texas. This is the law under the state of Texas, okay? So it outlines the counts, right? So it says count one, lesser included. I'll get to that. Count 2, and it goes all the way to count 5, okay? It goes count 1, 2, 4, and 5. Now, the state of Texas chose not to proceed on count 3 because her words were, he tried to put his penis in my mouth, and that's when I got myself together and put my clothes back on. Okay, so we're not moving forward on count 3. We have counts 1, 2, 4, and 5, and they're just written right at the top of the page, okay? Now, briefly, let's go into what a lesser included is, right? So you have count 1, lesser included. Count 2, lesser included. Everything you see in this packet is about aggravated sexual assault of a child, except for the lesser includeds. You know what those are? Sexual assault of a child, but no alcohol. So for some reason, you're like, Zach, look, even in his own words, there was the furnishing of alcohol, but you, for some reason, don't want to go forward down the path of the facilitation or the providing of alcohol. You have count one, aggravated sexual assault of a child, aggravating meaning alcohol. But if you're like, Zach, forget the alcohol, no way, fine. You have count one, lesser included. The lesser included here is sexual assault of a child. And there's not going to be any mention of alcohol. Does that make sense to everyone? You have aggravated sexual assault, 1, 2, 4, and 5. No alcohol, sexual assault of a child, 1, 2, 4, and 5. Okay? Now, on page 11, you're going to see something with respect to unanimity. Okay? It's going to talk about your verdict in each count must be unanimous. Okay? What I just want to make super, super, super clear is that it's about each individual count. Okay? So when you look at these, and thankfully the pagination works out quite cleanly. Count one, that's page 3. So you need to be unanimous to this page. Either unanimously guilty, which is what we hope you find, or unanimously not guilty, and then you move on, right? Does that make sense? So it's not, okay, we all have to agree on 1, 2, 4, and 5. Let's take it as one big block. Absolutely not. Take it count by count. You have to be unanimous with respect to each individual count. Once you have that unanimous either way, go on to the next one. All right, does that make sense? And a final thing, just to be super clear, mistake of age is not a defense. So think about the societal repercussions if someone could get up on the stand hypothetically and say, well, hey, I thought she was 18 at the time. It doesn't matter. Unequivocally, without hesitation or pause, know that these laws are passed in the state of Texas to do one thing: protect children so they don't have to take the stand in the first place. Okay? I'll reserve the rest of my time, Your Honor.
Thank you.
Thank you,
Defense?
Judge. May it please the court.
Good morning, we the people. Because the Sixth Amendment of the Constitution starts with the term "we the people." Sixth Amendment gives the person the right to a jury trial. That's why you're all here, all right? So, with that in mind, let's talk about the case. A child who's got a fake ID, a child who goes to bars, drinks alcohol in bars, takes selfies of drinking alcohol in bars, who's holding herself out at least 21 to get into bar. Apparently she looks the age, all right? So what do we have? We have a situation where they talk about getting alcohol. You got to remember, the charge is very clear. It says facilitating the commission of the offense. That means that the defendant, Mr. Delbosque, had to know that he was buying this 6-pack of Truly so he could have sex with her. That's what they've got to prove. I don't think that's what they proved. What they proved is he bought some Truly and some beer for a house party of at least 10 people. That's what they proved. They didn't prove any intent that he was going to buy this liquor to have sex with her. And that's what they got to prove for aggravated sexual assault on all accounts. All right. So let's talk about what evidence there is about alcohol. They found one bottle or can of Truly that she drank at the house. One bottle. Okay. Every law enforcement officer who testified did not reference the fact that they believed she was intoxicated. These are individuals, traffic cops, who work the streets, who pull people over for DWI, and they know how to identify intoxicated people. Not one of them testified, yeah, when we started talking to her, we noticed she was intoxicated. No, they didn't say that. What they said was she kind of shut up. Why did she shut up? Well, maybe this was a girl, 16 going on 30, that thought about, maybe I'm gonna hook up with an older man. She met him at the gas station. They got in his car, driving to the house. She's showing pictures of her cocktailing at a bar. They get to the house. They have a drink. Don't even know if she drank the whole drink. The bottle truly wasn't brought into evidence to see how much was in it or whatever. What we had was a swab from it that said she drank a drink. Okay. All right. So she gets to the house. She's got her cell phone. Cell phone to the point of, this is cell phone selfie girl, remember? Bars, everything else. Hey, look at me, Instagram. I'm posted. She's got her phone. All she had to do was pick up the phone. I'm being raped. 911. You heard the testimony that the phone kept on going off and off and off and off. Maybe it was the people at the party looking where she went. All she had to do was pick up the phone and say, hey, I'm in trouble. No, that didn't happen. She made no calls. She didn't call Uber. She didn't call the police. What finally happened was Mr. Delbosque gets pulled over for a traffic violation. She's in the car. It starts hitting the fan. She doesn't know what to do. Officer, he kidnapped me. He raped me. No, that wasn't thinking. She's thinking, how am I going to explain this? How am I going to explain this? Her mom shows up. My sweet little innocent daughter was raped.
I'm gonna object to proper argument, Your Honor.
All right, ladies and gentlemen, that objection will be overruled. You'll remember the evidence as you've heard it. You may proceed.
Okay. So when she's giving that statement to the sane nurse, what's in her mind? Mom's there outside. I don't want mom to find out that maybe what I did. So I'm going to be very, very specific as to what happened. But on the stand, she wasn't really that specific, if you recall. So the question is, yeah, it's a child according to the laws of the state of Texas. One size fits all. Would you call that person a child? Does a child have a fake ID? Does a child sit in a bar? Does a child drink alcohol? I don't think the state of Texas was thinking about that when they made that definition. It wasn't sexual, what's the term I want to use? It wasn't a forced sexual assault. She willingly got in the car with him. She willingly went to the house. She willingly had sex. He didn't get her drunk for the purposes of sex. There's no evidence that that happened. There's evidence of a couple bottles or a 6-pack of Truly and some beer and a bottle that was drank at the house. So, ladies and gentlemen of the jury, there is absolutely no evidence of aggravated sexual assault because there's no evidence that he facilitated the alleged offense by getting her drunk, because that's what you got to find. It just ain't there. Okay. Now, let's talk about the specific other elements. She claimed that there were other acts of sex besides the one act in the anus. Mr. Delbosque said, no, that's the only sex we had. So then you go to look at the credibility of the witnesses, all right? You have one girl who, for all practical purposes, is a liar. Hey, I got a false ID. I'm gaming the system. I'm 16 years old, but I'm sitting here drinking in a bar. And you got somebody who's made a mistake based upon a belief, based upon a representation, based upon, hey, she's in a bar drinking. I don't know what was going through this girl's mind. I don't know what her family situation was. I don't know whether she wanted to be older than she was, and there's a lot of things, but I do believe, based upon the evidence, that it was consensual. However, you know the story on that. So, with that in mind, let's talk about DNA. Yeah, there was some DNA floating around, but you remember that was also an unknown factor, an unknown specimen brought up. I don't know what this girl was up to. But, there is evidence. Now, also, I believe the sane nurse, or not the sane nurse, the first DNA person who testified, she said they did not find any semen on the vulva on her spray. All right. She claimed they had sex, vaginal sex, but they found no semen in her. Don't know. They're going to make a big deal about the selfie. Who in their right mind that they think they're going to get raped is doing a selfie? Hey, Instagram, look at me. I'm toast. You can, if you got kids, if you do Instagram and stuff, TikTok, people are stupid when you put a cell phone camera in their hand. They're taking pictures, they're doing stupid things. I don't think she was that drunk. I don't think she was drunk at all. She was sober enough, drive to this Valero station, sober enough to leave the party once. Remember? Dad shows up, busts the party. They scatter. Dad leaves. They all come back. They hang around for a couple hours. She gets in the car and says, hey, I'm going somewhere. Drives to Valero, hooks up with Mr. Delbosque. All right. So, sober enough to leave and come back to a party, sober enough to get in the car and drive away. And there's absolutely no evidence of how much she had to drink, where the alcohol came from. You're telling me they got a house party with 10 people and they shared 6, 7 drinks? I don't know, but I don't think she was intoxicated this entire time. She had her cell phone handy. She could have made phone calls. People were calling her. You heard Mr. Delbosque say that the phone was buzzing off the hook. It's her friends. Where are you? Where are you? What are you doing? I'm busy. I ain't going to take your call right now. So, ladies and gentlemen, I don't believe there's sufficient evidence to find any other count guilty except for the one that Mr. Delbosque admitted to do. He admitted, yeah, he did it. He stood up there and said, I did it. I had sex with her in the anus. I thought she was older. She represented herself was older. I don't think there's any other evidence to prove, credible evidence to prove that they had sex in the vagina, that he had oral sex with her, that he fingered her. All right. Did we hear any evidence of penetration with the finger? No. Did we hear any evidence that she had her underwear off when this happened? Was it through the underwear? Was it? No, there's no evidence of that. So I would assert to you, ladies and gentlemen, that based upon the evidence, the only thing I can see that potentially could be a factor is the first count. And alcohol was not the facilitation of that issue. He didn't get her drunk to have sex with her, and that's what the state's got to prove. And there's absolutely no evidence of that. Thank you, ladies and gentlemen, of the jury. I appreciate your service, and thank you once again.
State, you have 15 minutes.
Thank you, Judge. All I just heard was a lot of victim blaming. And you should be outraged. Blaming this 16-year-old girl for what that 49-year-old man did to her. How dare he? Let's talk about these arguments. You heard him say on the stand in a very memorable testimony, he didn't know how old Elise was. He didn't know how old Olivia was. That's bull, and we all know it. He dated Trisha for 5 years. He was in that girl's life through puberty. He met her when she was 11. Olivia was 16 when all this went down.
Judge, I'm gonna object. There is no evidence in front of the jury how old Olivia was. She's arguing.
His
facts
client
that
said
are not
that she
against-
was
Stop.
16.
All right, so everyone, direct your objections to the court. Defense, I've heard your objection. Ladies and gentlemen of the jury, evidence was presented to you, and you will remember the evidence as you've received it. Does everyone understand? You may proceed.
A man who had raised 2 daughters, who were now 25 and 27, so back then would have been 22 and 24, he can't tell who is a teenager? No. Don't buy it for a minute. He also keeps talking about this fake ID. There is no evidence presented by either side that Mr. Delbosque even knew she had the fake ID until later. Yes, there was talk of showing her photos, or showing him photos. And yes, Elise says she had the fake ID. That doesn't matter. He himself said he knew her for at least 6 months, possibly up to a year. He never saw a fake ID. What, maybe that night after he's been texting her for weeks, oh, all of a sudden now he gets proof that she's over 18? No. It doesn't matter. There's also all this talk of, oh, he didn't force her to drink. There's no proof she was drunk. That's not what we have to prove. All we have to prove is that he provided a substance capable of impairing her judgment to her. That's all. We don't even have to prove that her judgment was impaired. We just have to show what he admits to, that he gave her alcohol. He saw her drink at El Mirasol. She says he purchased it for her. We know that he bought drinks for the party, and then he himself even said he gave her a drink at the house. He provided alcohol, a substance capable of taking away her ability to understand what's going on. There's also talk during his testimony of, oh, she made the first move. How dare he? Even if she had, it doesn't excuse raping a 16-year-old. So let's briefly talk about consent. You're going to see some slides from Baudelaire. Under the age of 17 cannot consent, period. It doesn't matter if she texted him. It doesn't matter if she willingly went out to meet him. It does not matter. That is a line in the sand to protect children. It doesn't matter how close to 17 she was. She was 16, period. And again, as I just said, all he has to do is administer or provide. He provided alcohol. No force necessary, no drunkenness necessary. Now let's talk about Elise's story, which I'm also going to show you all the evidence that backs it up. And you get to take what's admitted. So you guys can take back the picture. You can take back the text. And if you have any questions, I encourage you to read the text. Now remember, these are just the texts from that day. You'll also get to take the same exam that Linda Whitty testified about. You also get to take his interview back. Because if there's any questions, those are going to clear them right up. Elise's story that she is stuck through and is evidence also in the same exam, they met up, got the alcohol, and he kept texting her. And when you flip through and read these, you'll see that he's the one being like, hi, when can we meet up? When are we gonna hang out? He pushes it, she doesn't. So I'm gonna highlight a few of these. Elise texts him, hey, her dad, meaning Olivia's dad, her dad's just came to the house, and he says, oh, so what now? Well, leaving and coming back then when he leaves. If he doesn't know she's a minor, what does Olivia's dad have to do with anything? Why would that prevent him from going over to the house to hang out? If they're all adults, why does he care if another adult man is there? Because he's a liar, and he's a bad one. You'll also see where he tells her, hey, I got some Truly, some Michelob, let me know when you're ready. Oh, I also have some barefoot wine. Pushing her. And then as he's waiting for her, somebody who's claiming, oh, I have no intention of flirting with her. I have no intention of doing anything sexual. As late as you need, baby. To a 16-year-old. Yeah, no, he didn't mean to do anything. He wasn't planning anything to happen. That's a lie. He knew she was drunk. He knew she'd been drinking, and he pushed her to leave that house. He pushed her not to let him pick her up, even though he knew she'd been drinking. No, he wanted her to leave the house and be picked up somewhere else so no one else would see her leave with him, because he knew what he was doing was wrong. He knew she was a child, and he didn't care. You'll also get the SANE exam. I've just highlighted some things. There was a lot of stuff made about, oh, well, there's nothing about getting food. And she says, no, well, he called me. She says that 3 years ago in the SANE exam. Jose called me and said, I can go for food. Consistency. I thought we were just gonna go get food. He gave me a drink. He started kissing me. He kept having sex with me. He would grab me and keep me from putting my clothes on. He just kept pushing me. I tried to push his arm, but I couldn't push him off me. I kept saying no. Read the narrative. You'll have it back there. And you'll also talk about Linda said the yes/no questions. Was there penetration of his penis with your vagina? Yes. Was there penetration of his finger in your vagina? Yes. Did his penis go in your anus? Yes. Did his finger go in your anus? Yes. Did your mouth touch his mouth, or did your vagina touch his mouth? Yes. It's all in there. But most importantly, there's this. Here's more evidence that it went into her vagina. The injuries on her hymen and her labia minora. All in there, all documented. Probably the most heartbreaking part. She declined the anal exam. She did not want her parents to know she was assaulted anally. And Linda said that she was so tense and so closed off that she pulled away when Linda tried to touch her. And she told you that that was the most pain she'd ever been in. Because what 16-year-old is going to say, yeah, let me go hook up with this 49-year-old man. You know what we're going to do? We're going to jump straight to anal, no prep, no lube, no condom, and I'm going to be so injured that it hurts. But that's what I'm down for. No, he raped her. He forced her. And it wasn't just the anus, it was also the vagina. And how dare he blame her? The DNA is everywhere. Both of their DNA is on the can. Her DNA is on his penis, along with another person. We don't know who that other person is. Who knows what he was up to, not what Elise was up to. Her DNA is on his hands. His DNA is on her face and mouth swabs. His DNA is on her breast. Male DNA was found in her vagina, but not enough to quantify or test. He wants you to sit here and say, oh, children with fake IDs had it coming. No, she did not have this coming. She did not want this. He raped that child, and you need to find him guilty on all 4 counts and finally hold this grown man responsible for what he did to her.
All right, ladies and gentlemen, Deputy Laura is going to take you to the back.